Good morning or good afternoon, everyone, depending on where you're joining us from. It is, I believe, noon on the East Coast and a nice early 9 a.m. in California. It's 11 o'clock here in Texas. We're going to go ahead and get started. And not to forget Denver, it's 10 a.m. in Mountain Time Zone. So familiar with time zone differentials because I travel a lot for different cases around the globe handling military matters. People are stationed in Germany, Japan, and every time zone in between. So it's quite exhausting getting emails from Japan and Germany at the same time because they're in various time zone differences are quite significant. But regardless, today's presentation is a generic overview of the military UCMJ investigation process. There's multiple types of investigations in the UCMJ, and we'll move on to slide 2 to just to show you about me real quick. So I'm the managing partner of our Houston office. I'm also been with Tully Rinckey for approximately 9 years now. I've been an attorney for approximately 16 years. Wow, it's been a while. I thought I was younger attorney, but now I'm 45 years old and gray haired and wrinkled everywhere from all the case travel and case experience I've acquired for a decade and a half plus now. Been with Tully Rinckey for 9 of those years. Prior to that, I was with the Army at Fort Hood, now known as Fort Cavazos. And I spent a significant amount of time in the JAG Corps being a government attorney, working for the government. So I know the inside out playbook they work with. It's the same playbook pretty much on every case. Often I tell my clients exactly what's going to happen because I know the playbook. They usually don't believe me because the unit's telling them something different. And then they find out later everything I predict occurs. And the shock is usually jaw dropping, but it's not shocking to me because I know the playbook. I also know the deceptive lies the command will tell you while they're trying to lure you to admit stuff against your interest. So you want to be mindful of deception you're going to face from your command. Your command is going to lie to you. I guarantee it. They're going to tell you a bunch of BS and nonsense deliberately to get you to remove your guard. We can move on to slide 3 now, overview. So today's presentation, and if you want to learn more about me, look at my bio, you can read the news. If you want to read some interesting case stories, you can Google me. Lots of different stuff. And I do advise everybody on the case stories. Just like an ER doctor does not pick their patients, I don't usually pick my clients, meaning if you hire me, I will give you 110% zealous advocacy. Just like a doctor who's facing a patient who's shot in the knee, whether they're a victim or they're a fellow criminal, it doesn't really matter. They have a knee that's been shot and needs to get fixed. That's how I treat my clients. So some of my clients are difficult to work with. That's okay. The more challenging, the better. I love the challenge and I love helping people out who are in difficult circumstances. So you may see that reflected in news stories and think to yourself, wow, my goodness, how could he represent someone such a horrible situation? Well, doctors have to fix patients, and my job as a lawyer is to fix people's legal problems. So the more problems you have, the more likely you need some services to assist in getting things worked out. But overview here. Today's presentation is going to cover the overview of the generic process for UCMJ investigations covering the Army, Navy, Marine Corps, Coast Guard, Space Force, and the Commission Corps of the Uniformed Services, Health Services. So we can move on to slide 4 now. We will not be covering UCMJ, non-judicial punishment. That's Article 15, also known as NJP in the Marines and Navy. We're not going to really cover that to full extent. What we're going to talk about is just the initiation of the investigation and the gap between the time you're under investigation and flag pending resolution and the time a disposition happens. Disposition meaning they decide to give you NJP or a reprimand or not do anything or refer to civilians for further prosecution. There's lots of options the command will have when they have information in front of them. This is about what goes on during the actual investigation. This is the gap. A lot of times individuals are really, this is the most scary time because you don't really know what they have, what they claim to have, who said what, who's complaining, what's the nature of it, and how bad things are, or how bad they aren't. All you know is the limited disclosure you're given that, hey, you're under investigation for X, and we're going to flag you because we need to have this investigation resolved or any favorable action can happen for you. That's a very scary position to be under because you may be the victim of a fraud. You may be the victim of of a hoax. You may also have a guilty conscience about something that they don't know anything about. So you may want to run down to the station and admit to your guilt for something they have no knowledge even occurred. So you really need to be mindful that this is the opportunity to say nothing, to lawyer up, be protected by counsel, and have counsel work to reverse engineer what, if any, is your exposure. So we're going to discuss your rights during the process. The most fundamental right you have, and you probably should know this from watching TV shows, but it's worth saying again because a lot of people seem to forget this when they're under the heat of exhaustion from the duress associated with an investigative inquiry, is you don't have to say anything to the police or the authorities or the command. You have an absolute right under Article 31, under the Fifth Amendment of the Constitution, to refrain from self-incrimination. So even if you are conscious of guilt, the only person you need to confess that to is your deity. Meaning, if you want to go talk to clergy later to clear your conscience, that's on you. Legally speaking, you should be absolutely quiet and say nothing unless advised by counsel. You can be compelled to testify if you're given immunity, but that's a rare exception, and that's an exception outside the scope of our presentation. But I wouldn't say anything unless you have a rock solid immunity document in front of you that's been vetted by an attorney, and that clears you of culpability with that immunity. Absent some complete immunity to cover your exposure for liability, you should refrain from discussion unless you have a basis to provide information. And there may well be a time when that's appropriate, but you want to have that vetted through counsel. So if you're accused of a bank robbery in Oregon, but you have absolute confirmed proof you were in Florida during the time this robbery happened, your alibi can be documented and proven by disclosure of information, you may want to provide that to show your alibi so they can find the actual culprit, the actual suspect, maybe to get you out of the investigative inquiry. Absent an alibi defense, it's very rare you want to provide any information. You generally want to be quiet and say nothing, and then in the future, present your side of the story, if appropriate, at a later time. So let's move on to slide 5. Initial considerations. Just because you're being medically separated or pending retirement or in sanctuary does not mean you won't be investigated. So if you get accused of, one of the more heinous crimes, sexual assault, and you're 2 days from retirement, they're still going to do an investigation, regardless of the fact that you're eligible for retirement. They have a report of a serious felony. They're going to conduct a full scope investigation to determine if there's merit to those accusations, and you're going to be under scrutiny for a very long period of time. The biggest one for investigations is generally sexual assault and or sex crimes, internet-based crimes, child pornography. Other more salacious accusations are often bases for opening up felony-level investigations by CID, OSI, NCIS. Who are they? CID is the Army Criminal Investigation Division. They wear civilian clothing, but they're members of the military, and their job is to be detectives to determine if there's evidence to support charges for crimes. Same with NCIS. You may have seen the TV show. It's not Navy crime scene investigation. This show is obviously Hollywood. Takes a lot of liberty with the reality behind it, but it's got some generic reality. It's got some basic truth to it. They investigate crime, and they make reports, and they advise the command, and then people get potentially charged and prosecuted based on the evidence they collect. And OSI is the Air Force Office of Special Investigations. All three have the same function. They're the military detectives that their job is to put you away. Their job is to prove that you committed whatever offense they believe you may have committed. Their job is to investigate crime. Often they think their job is to prove it happened even when they have an accusation, even if the accusation is clearly lacking in merit and in civilian police would laugh it out the door. The problem with CID, OSI, and NCIS is they have this mentality that if you're accused, you're automatically guilty, and then they're deficient if they don't prove the guilt based on the accusation. They tell you, oh no, our job is to just line up the facts and let the facts speak for themselves. That, in my opinion, as a civilian defense attorney for 11 years in private practice, is total horse manure. Their job is to get a latch under their belt by putting you away. Don't trust them. Don't eat donuts. Don't talk to them. Don't go in there and tell your side of the story. Because guess what? If you tell your side of the story to them, what have you done? You just admitted you know what they're talking about. You admitted you were there where it happened. You admitted you know the person complaining about you. you've admitted almost 80% what they need to prove you're guilty. And then all they have then is the statement from the quote victim and your statement. And then they can say, well, you didn't admit to what the victim's saying, so you're lying. Now you just lied to us. So if we can't prove you committed the offense, we can prove you're lying because somebody else said you said something different. That's how they can get you, which is why you absolutely, under no condition, without an attorney and an immunity agreement, want to ever talk to them, because just by talking to them, you're setting yourself up for a perjury trap where you can be prosecuted for, quote, lying to the investigators or obstructing justice or interfering with an investigation or however else they want to charge it and manufacture culpability and liability and put you under duress to plead guilty to something. By giving them anything, you're probably giving them something to work with to say you're a liar and you should be incarcerated. Pretty draconian stuff, huh? Well, it's the reality we face. It's the reality of a very corrupt system. And again, I'm jaded, I'm exhausted, I'm burned out from representing people time after time who've had their home raided, had their life ruined, had their family destroyed from excessive government overreach. So you're talking to somebody who experiences the worst case scenario pretty much every day when it comes to my cases. So if I'm biased, I admit fully biased. So if you're an FBI agent and you're like, no, we do everything but board and we absolutely are professional, okay, great. I'm sure that's true in your situation. But I deal with the times when they're unprofessional and they're overzealous and they make a mockery of justice and they harm innocent people. And I've seen too many of those scenarios to say everything being done is legitimate and above board. Often it's not. So let's move on to slide 6. That's types of investigations. So here's the types of military internal investigation. There's a commander's inquiry. Somebody's late to formation. So they say, hey, Sergeant First Class Smith, why don't you look into what happened with, PFC Jones here? Why was Jones late? That's an inquiry into what's going on with PFC Jones by an E7 looking into an E3. Relatively standard inquiry, may or may not involve a written report, may involve, written counseling to the private soldier there, may involve further documentation, may involve enough documentation to actually administratively separate the soldier. But being late to formation a few times is pretty minor. It could be serious if it happens repetitively, but it's not something that you really need to have a lot of paperwork on to really get too many others involved. And it can be done by members of the unit. An administrative investigation is more formal. This is usually when it's a more serious accusation. So we got evidence that one of our platoon leaders is sleeping with subordinate soldiers and sexually harassing them. That could be a very serious set of accusations. Sexual harassment is taken very seriously in the military, and accusations of it are required to be investigated formally by the appointment of an investigating officer who's senior to the soldier investigated, and to look into and go ask questions. To go ask all the soldiers. So is this true? Is Lieutenant Smith sleeping with forcing himself on soldiers? Is he using inappropriate language? Is he acting in an unprofessional manner? Is he conducting himself in a manner that's hostile to a proper workplace? Those are all questions that will be asked and vetted and could result in adverse action. But again, that type of investigation is administrative. It's really to see, is there a basis to believe the accusations for what's occurred here should result in this person being separated from the military, basically fired. Generally, if you're accused of sexual harassment and it's substantiated, there's a mandatory separation board process. Same with drug use. So also a drug use accusation would be an administrative investigation generally. So if you come up hot under your analysis, they'll put you on investigation. They'll look into it, see if there's if you have any explanation or innocent ingestion justification. If you don't, then they'll probably move to separate you, and you'll have a board where you'll have an opportunity to present your side of the story. But a drug hot inquiry or a sexual harassment complaint is usually just an administrative investigation. Gets more serious. So if security police from the Air Force or military police from the Army get involved, often in like burglaries, traffic, reckless driving, patrol officers may actually arrest somebody for reckless driving and put you in the local lockup on the installation, and the unit will have to come bail you out and release you back to your command the next day. That's more of a lower type investigation. Reckless driving, you might get serious trouble, you might pay a massive fine, you might have your driving privileges restricted, but it's going to be resolved and your life will move on. You may have to have higher insurance rates or something, but you're not going to face the end of your life type scenario. The point of this webinar is to really talk about the last one on the slideshow, the felony level investigations. This is the investigations resolving, murder, rape, espionage, fraud, you name it, the big felonies. Espionage, very, very serious. So they think you're working for the Chinese government, sending secrets to them. You're going to be under a massive felony level investigation by CID, and you may get prosecuted. And it may be something innocent too, but you have to be very careful. If you have access to classified documents that are authorization only review, and you share those on social media, or you share them with public, or you share them with your sister, you can be prosecuted on a felony level, even if you think it's relatively innocent, taking a picture of a document. Well, if you disclose where the alien bodies are, I guarantee they're gonna. I'm kidding about that. But they're gonna prosecute you as a felony level offense. So if you have access to this information, don't disclose it. These are highly trained investigators of OSI, NCIS, CID, and their job is to put together the packet that's going to, lack of a better description, put you away and potentially ruin your life. We'll talk about the one that comes up a lot. Those are sex assault cases. A lot of sex assault cases don't have the scenario where you have an ATM mugger and they attack somebody physically and they forcibly harm them. A lot of them are dating relationships that go south, and people complain months later. OSI still does, CID, NCIS still does a full, thorough, felony level investigative inquiry to try to corroborate evidence. And they may not have any evidence other than the statement of the accused. But if you volunteer information, they're going to have a lot more than they did from the complaint if it's done after the fact. If it's done fresh, they may have immediate evidence such as DNA, other collectible evidence, and that could be really catastrophic to your ability to defend yourself if it corroborates the story from the alleged victim. So you have to be mindful about the severity of your liability. Often depends on the timing and the strength of the evidence they have, but their job is to make whatever evidence they do have look as strong as possible and make you look as culpable as possible for whatever you're accused of. So let's move on to slide 7, the general rule here. Again, I've said this a few times, but I can't beat this. I'm going to beat dead horse until it's fully gone, because half my business is when people hire me after they've already admitted everything. If I could reduce that, I'll have less work, but people will have more of a livelihood to them. And that'll be a benefit to society as a whole. Because the number one reason people are sitting in jail today in America and in the military is because they talked and they admitted and they basically gave themselves up. If you value your freedom, if you value your livelihood, if you care about your family, you will not talk to the investigators. You will lawyer up and you will be quiet. If you are cavalier and reckless, go ahead, talk all you want, but you're just burying yourself alive. Under the Article 31 of the UCMJ, you have a right to remain completely silent. No one can force you to provide incriminating statements, again, unless there's a grant of immunity. But again, you want that immunity grant vetted by an attorney to make sure it's legitimate. It's perfectly legal. This is the part I've been emphasizing from the beginning, and I've already mentioned it, but it's worth noting on the slides. These investigators are statutorily authorized to lie to you. They will tell you whatever nonsense, whatever whopper they think is necessary to get you to disclose the information they want to hear. And examples of lies. Oh yeah, we totally know that you didn't do anything wrong. We know she totally was into you. What happened? Oh yeah, we're certain that she's lying. We absolutely believe everything you've told us. But really, man, what really happened? That's an example of how they'll get you to let your guard down. How to be a one-on-one with them and just basically give them all the information they need. They'll try to be your pal. They'll try to get you to eat the donuts, drink the coffee, whatever, get comfortable and just tell them everything about your life. That's not the time to discuss your life story. That's not the people to confess to. All they're going to do is document everything and use it against you. During the course of investigation, we can also try to figure out what they have. and get the investigators themselves to show their cards. That's why you need a lawyer involved to try to flesh out from the investigators, the investigating officer, the CID, OSI, NCIS, the command, what do they really have? And what are they really looking to do? Because you may not know. You may be guessing. And the attorneys can have a frank discussion, attorney to attorney, about the scope of the case and the seriousness of the case. Because attorneys, they do bifurcate their work based on the seriousness of the accusations. You know, prosecutors who are focusing on a murder case may not care much about a burglary case. If you're accused of burglary and they're focused on a murder trial, you may be able to get the information. They don't really have much about this accusation of burglary. And since they don't really have much, they're probably not going to do anything with it. You may be able to find it out from your counsel, have your counsel talk to the attorney from the government. Otherwise, you may be sitting in limbo for 9 months wondering what in the world's going on. Polygraph evidence, sometimes they offer, hey, if you're so innocent, you didn't do anything wrong, why don't you come take this test, polygraph, and just tell us the truth. That's the wrong answer. Polygraphs are not admissible, and they're never really a good idea. The test is not reliable. They're inherently flawed, and all it's going to do is get you to just blab out stuff that nobody needs to know about. Nobody needs to know about your private sexual behavior. If it's private, if it's consensual, and it was lawful, nobody needs to know the details. But people love to sit in these polygraphs and tell all kinds of stuff that's on their conscience. Not a good idea. Statement provided in violation of Article 31 may be inadmissible. So if they coerce a statement out of you without giving you rights advisement, it may be inadmissible. You may be able to get a confession thrown out, especially if you're under duress or you were locked in a room for 6 hours and not given any water and you just started just talking to get out of there. That may be a basis to say you were coerced. Again, though, it's a high bar hurdle to get a confession tossed for coercion or duress. It's a very high hurdle. So it's best just to take the general advice now and not say anything under any condition. Even if you are totally confident in your innocence, they may not. They probably think you're guilty though. If you're there, they think you're the bad guy, even though you may personally know you didn't do anything wrong. That's not what they think. So you better be quiet. And accused own statements to investigators are usually the most incriminating evidence. In fact, the case in chief is usually that's usually how they get people. I had a case where they had nothing on my client except his own statement mumbled under his mouth on recording, and he said words to the effect of, I really hope she, goes away, or something like that, much more graphic than what I just said there. That was consciousness of guilt. That was an admission that, he really hates the quote victim, and that's proof for the jury to say, you know what, that's consciousness of guilt. This person was guilty. If they didn't have that, probably would have been found innocent. Had he not talked, he would have had a much stronger case. But he talked and he gave them everything they wanted to hear. So he was found guilty, unfortunately. You can avoid that scenario by not talking. You can avoid the fate of so many others who sit in jail today if you just be quiet. So don't say anything. Again, that's the point of this whole presentation, is if you're under investigative inquiry and you're facing scrutiny, don't dig yourself a bigger hole. All right, slide 8 now, please. This is how the process generally works. An accusation is made. So a victim speaks to a friend who tells the supervisor, who tells the command, then they start the process. They look into this. An IO is appointed to identify witnesses, identify the suspect, interview these witnesses, interview the suspect last, prepare a report, have that report drafted, send it up to legal for a review. Legal usually just rubber stamps it, says, yeah, it looks good, okay, next. I don't really care. Even though it's got tons of flaws in it, they just rubber stamp it and say, yeah, it looks like it put together something that's halfway decent, spelled in English, right? Okay, good enough. He's guilty. Move on to the next file. They never scrutinize what actually put in these investigations. The logical faults in these inquiries are usually laughable, and the JAG, who's quote reviewing it, usually spends about 2 minutes flipping through the file. Oh, you interview people? Okay, great. You got some witnesses? Good. Okay. You put together a report? Wrote it, sounds logical. Okay, approved. Next. That's about the extent. I know that because I was in ad law and I watched other attorneys do exactly that. I pushed back, and guess what? I left active duty. I left active duty pushing back because I got tired of being told we have a system that we're going to just continue to operate in, and we're not going to change it. And we're going to continue to operate with injustice, and we don't care. So I went to private practice to fight injustice, and I've been doing it for the last 11 years. But most of the uniformed attorneys are drinking the Kool-Aid, getting paid, don't care, and just rubber stamp things one after another. And that's unfortunately how you get so many investigations that are a complete joke that result in adverse action, and then you have to hire some private counsel to push back on, because the attorneys, they're overworked and exhausted, and they just ran 5 miles for PT in the morning, so they really don't care about what they're doing at their job. That's often true. Not true for everybody, but true enough to, I see enough crappy investigations get approved to know it has to be the reality. Either they're completely dim-witted, or they don't care, and I think it's more likely they don't care. All right, the more serious consequences can also result in, you having charges preferred, and charges preferred result in your right to trial by court-martial, and you'll have a lot of due process there. If they take adverse action, such as administrative action, you may or may not have a right to respond. You may or may not have a board to tell your side of the story to. It really is depending on which lane they take in the investigative process. Do they take the prosecution lane, or do they take the administrative lane? If they take the administrative lane, you'll have less due process, but you'll have less liability and culpability and adverse action against you, but your career may be coming to an end. If they do the court-martial process, you could go to jail and you could have your life ruined and you'd be dishonorably discharged. So it really is depending on how serious they take the accusations and the evidence basis they have on you. All right, move on to slide 9 now, other considerations. So CID, NCIS, OSI, 3 different agencies, but they all operate in a very similar manner. They should reach your Article 31 rights if they call you in. They're going to ask you to sign a waiver and talk to them. So, get the story out of the way. Tell us what happened. Tell us what really happened. Tell us how you're innocent. Don't fall for it. Don't talk. These agencies can also take assistance from other offices and get coordination with outside entities, Department of Justice, FBI, local civilian authorities. Their reach is pretty much worldwide. One question I get often when people are under investigative inquiry is, why is this taking so long? And that's a great question. It's very logical. And the answer is the government's super slow. They move about as fast as the DMV when it comes to issuing licenses. And they often have to send documents out for outside expert reports. These outside experts have outside contracts that are funded by the government. And the contracts are often paid late, so the work just piles up and it gets neglected for a long time. And eventually they get to it and put together a report. All that time you're sitting in limbo wondering what's going on. Digital forensics and DNA reports can take many months, if not a year longer, to come back. So while they're waiting on DNA to come back, you could be sitting in limbo for up to a year. And your lawyer may or may not be able to do much for you during that time. It's not the lawyer's fault. It's the problem of the investigative process being slow and the lack of resources the government allocates to and how serious they take the investigation. They take some investigations much more serious than others. If your investigation is a lower priority, obviously it's the most important thing in your life, but to the investigators, to the command, it's probably on the lower end of the spectrum, and it may take a long period of time. So you have to be very mindful of that. You may be called in to get titled and fingerprinted. So if they have probable cause and believe you committed an offense, they're going to call you and say, hey, you need to come get fingerprinted. That's going to go into the national database. That means you've been titled, meaning an attorney says there's probable cause to believe you committed an offense. Even if the command does not prosecute you, even if you never get any charges, anything ever happens to you, if you've been fingerprinted and titled, when you apply for jobs in the future, on your background check, it's going to come up as you committed an offense. You need to get out in front of that and say to prospective employers or prospective background check being run, hey, I was investigated for this, nothing happened with it, I was totally innocent, but they put down in the system that they accused me of it. And that explanation will get you out in front of the response usually from employers, hey, you committed a burglary, we can't hire burglars. I was like, I didn't commit a burglary, what the hell are you talking about? Well, you were fingerprinted for it, you were titled for it, you were investigated for it, and they found out actually the roommate next door committed the burglary, not you, but they never went back and removed it. If you need to get this removed, you need to take proactive steps to ask the titling to be untitled. There is an untitling process application outside the scope of this webinar. You'd probably want to have that done. If you've ever been accused and you've been fingerprinted, and you've been titled, you absolutely want to get that removed because it's going to show up and they're going to think it shows up as a conviction. And then you were, quote, convicted of something you didn't ever get charged for. It's the most frustrating thing I run into day in, day out because it's completely inaccurate what they're saying to you, but they don't understand how to read it. And they're civilians looking at military records. So they think it means you were convicted of something when you were just accused of something. Huge distinction there between a conviction and an accusation, but they read it as a conviction. Then they deny you a job because the other person who they're looking at has nothing in their background and you do. So certainly keep all those considerations in mind and work to get yourself untitled. If you've ever been fingerprinted by the military, that means you've been titled, and that means there's negative paperwork in your file for 40 years, and you certainly want to move to get that done. You get that removed if you can. And if you can't, you need to disclose it and try to make it sound as innocent as possible. All right, slide 10 now. Other commanders' options for disposition. So they have the option under the UCMJ to take no action against you all the way up to court-martial, general court-martial, full felony prosecution, put you in jail for life, potentially if the charges call for that kind of punishment. Or they can take an admin action, bar you to enlist, show cause board, separate you, corrective training, informal counseling, reprimand, all kinds of options at the discretion of the command. Now, some cases now have been taken out of the purview of the command, and they're done by the Office of Special Trial Counsel. So the rape cases, the murder cases, those are done by recommendations from a special division of the JAG Corps known as the Office of Special Trial Counsel. But assuming it's a regular, ordinary military offense, it's still entirely within the purview of the command, and they will make the decision on what to do with it. Now, preparing a response to the investigations. Let's go on to slide 11. All right, what you want to do now while you're under investigation, and you want to fight back, you want to be proactive, you want to start gathering character letters, you want to start gathering positive statements about you, you want to gather what's called the good soldier, Marine, Airman, Sailor evidence, to include witness statements, character evidence, and potential explanation justifications, such as, yes, I took the money, but it's here, I give it back. Or, yes, we did have, sexual relations, but it was all consensual. Or, yeah, I punched the Marine, I sure did, but I was defending myself. He was trying to kill somebody. Or, yes, I know the drugs in my system. I ate a brownie, and I found out later it contained marijuana. Those are types of defenses you may want to have ready to go in your back pocket when it's your time to present your side of the story. Not immediately to OSI, but through counsel later in a hearing or in front of your command, or when it's appropriate to disclose, if ever. If you have a justification or extenuation of mitigating evidence, you want to present that at a later time. During the investigation, it's your opportunity now to start gathering that stuff up. If you have medical defense, if you have a disease that may impair judgment, and you want to use that as a basis to say, your liability should be lessened, you want to start gathering your medical records now. All that, this is the time to put all that together, is while you're under investigation. Don't wait till they do something. Start gathering positive things now. Get organized, get your material together, and you should be in good shape. All right, go on to slide 12 now. Some applicable regulations, just for everybody to have in front of them. The Army has the enlist separation regulations, the officer separation regulations, and the Centers for Medical Fitness. The Navy has the Milper's Man on the same stuff, and the Air Force has the instructions. So the Army calls it regulations, the Navy calls it Milper's Man, and the Air Force calls it instructions. It's all the same thing. Coast Guard calls it ComStat, but it's all really just their interpretation of the statute, the law, and how it applies. Different services use different regulations and different terminology and different procedures, but they all have to comply with the same UCMJ provisions and the same UCMJ case law. We have experience with former JAG attorneys in each branch of service in our firm. So I'm a former Army JAG. My colleague Tom is former Navy JAG. We have former Air Force, former Marines. I don't think we have any current former Coast Guard JAGs, but we have every other branch. And I've done plenty of Coast Guard cases here in Houston with the Coast Guard down there in Galveston. So I'm very familiar with the Coast Guard process. We have an attorney who knows your service culture and regulations, and we will be able to assist you. And not just us, but any of our competitors can do the same thing. But we're the only law firm in the country that I know of that has about 20 veterans on the payroll. We have 75 plus attorneys. 20 of us are veterans. the population is probably 2% veterans, and the population of lawyers is less than 1% veterans, and our firm is a third veterans, or less than a third. A good chunk is veterans. A good 25, 30% are veterans. So we are a very veteran-specific law firm. It makes us very unique because, again, most law firms, if they have a veteran, it's 1 out of 100 or less. And our firm is a good chunk of veterans, good chunk of military people. All right, going on to slide 13, some significant case victories. All my case victories, recently at least, have generally been when my client has been quiet, not talked. It's very, they were smart, they lawyered up, and we were able to get the stuff thrown out, or prove they're innocent, or get a full acquittal because the accusations lacked merit. If they talk, it's hard to dig yourself out of that hole, which is why I'm telling everybody ahead of time, don't talk. Now, I've had case victories where we had confessions thrown out of evidence, meaning they admitted to the offense, but they were under duress or coercion, and we filed a motion to suppress, or the government engaged in some other misconduct. And the point I'm making is, yes, you can still win your case if you've already confessed or you've already given them adverse information through a disclosure of admissions against interest by talking, but you're then relying on the government to fumble the ball. It's much better for you to be on offense than to be on defense and trying to kick the ball out. You can control your offense. You can go 5 yards at a time and get to the end zone. If you are relying on the other side to make a mistake, it's a lot harder. Certainly doable, but it's more difficult. I hope that analogy makes sense. But if you're relying on the government to make a fumble, fumbles don't happen as often as just regular ordinary touchdowns. It's a lot easier just to score a regular standard touchdown marching down the field than it is to rely on a turnover. So be mindful of that. Don't talk. And if you do, you need to try to backtrack as fast as possible and get counsel to clean it up so you can get on a good footing. And we've had great victories. Often early advocacy gets the command to say, you know what, this is not worth it. Let's just drop it. I've had a case recently where they went to the authorities, the military got involved. We provided notice representation, and they said, you know what, it's not worth it. They gave it to the civilians, let the civilians look into it. Civilians looked at it, said, yep, there's nothing here, entirely dropped. But for our early intervention, they very well may have let the process play itself out for the duration. But because they realized it was not going to be an easy win, they dropped it. They dismissed it. They said, you know, the heck with it. That happens all the time. So you want to have a strong posture immediately once you're under scrutiny. You've got to bluff them out. You know, if you show up poker faced, that you're going to make the government miserable if they put you under, they come after you. They may decide, you know what, this is not the case where it's worth dying on the bridge for. We're just move on to something else that's easier victory for us. And they're all about wins and losses. They say they're about justice. That's nonsense. They're about picking their battles and getting victories under their belt. And if they know you're going to be a difficult case to prove, they're probably just going to drop it. So, you know, it's not worth it. We're going to use our discretion to say we'll find something else later on this person, if ever. So, and also, if you've ever been under scrutiny, be mindful of the fact that you'll be under scrutiny for the duration of your career. So you got to be very careful going forward. If they can't get you this time, they'll certainly try to get you in the future and then use the stuff they have now against you later. All right, slide 14. We're running out of time here. It's been a privilege to speak to everybody today. I hope you got the thesis here is don't talk. If you have talked, get a lawyer involved before you talk any further and protect yourself, gather your own evidence, gather your materials, be prepared. Don't waive your rights unless you've talked to counsel first, and understand that your benefits are on the line. Millions of dollars in benefits over the duration of your life could be lost simply by a few mistakes you make when you're under scrutiny for what you may think is a minor situation. Take it very seriously. And by taking it very seriously, you're not only protecting yourself, you're protecting your future self, because once you've been convicted, it's very hard to get that erased from your record. You want to prevent the catastrophe from happening before it occurs. So use this as your forewarning of not to do what you may have done had you not known. Don't talk to CID, OSI, NCIS. I know they hate me for that. And I know the government prosecutors absolutely hate my guts. And I'm convinced there's voodoo dolls out there around the world against me. because of the bad luck I have every now and then. But I'm okay with it because the more they don't like me, the more it means I'm helping you out. And I'm helping serve in the interest of justice by protecting innocent people. So that's just my little, I'm kidding about some of that, but I hope you get the point. Put the stress on your attorney. Don't live with the stress yourself. All right, does anybody have any questions?
I think there is one question, Sean. Can you sue for wrongful breaches of contract that turn into harassment?
Well, you certainly can sue for a breach of contract. If you have a contract that's legally binding, document, and the terms and conditions have been violated, you can sue under the contract. Absolutely. That's why you have a written contract, because it's documenting something that's supposed to happen. And if somebody violates the terms and conditions of that contract, yes, you can certainly file suit. Now, that leads me to another question. Can you sue the investigators in the military for causing you harm? The answer is probably no, because they're given what's called government immunity. So if CID kicks your door in, knocks your stuff over, breaks your things, you file a claim with the claim service to get paid for the damage to your property. They may or may not pay you, but can you sue the agent who dragged you out and caused you to have knee damage and pain? Probably not. They're given what's called qualified immunity, and that immunity protects them from liability, so you probably can't sue them for what they did in their official capacity. So I get that question all the time. Can I sue the police? Can I sue the investigators? Can I sue the command? Generally, the answer is no. Also, there's a doctrine in the military called Ferry's Doctrine, which limits suits against the military for anything related to military service. It's a very harsh doctrine, because what it means is if a doctor cuts off the wrong leg in the military, they have no liability. Your only remedy is to go to the VA and say, yep, I'm missing a leg. It's a terrible doctrine, but that's the current law that exists. So the Ferris Doctrine limits your legal remedies and legal recourse significantly when you serve the military. When you sign that military contract, you take that oath of office, you are affirmatively waiving most of your rights. You do have rights, but they're significantly contractually limited based on your agreement. That's why they made the military all volunteer to some extent, because draftees were forced into it, and then getting them to comply and obey orders was very, very distracting and difficult because they didn't want to be there and they were forced to be there. Having an all volunteer military makes the military believe they can pretty much do what they wish because you agreed and you signed a contract and you're getting paid and you volunteered for it. So be mindful of what you volunteered for. Last warning about that. And this is something draconian, but I don't think it's emphasized enough, because I get parents all the time who call me and they tell me, oh, they're being mean to my son. Get him out of the military. What do you mean they're being mean to your son? He's in basic training. Of course they're going to be mean. That's their job, is to train this person from a 18-year-old kid into a person who's going to go fight and kill the enemy in war. They're going to be rough. And in fact, if they're not rough, they're not doing their job. So it's going to be difficult, but the environment you face in training is not the environment you will experience when you get to your regular duty station. It should be a lot better at your regular duty station. So when you sign up for the military, just like the investigators lie to you, the recruiters, guess what? They're going to lie their butt off. They're going to lie significantly. I would say more profane words, but this is a public forum and YouTube video disclosed in the future. But the recruiters, they are paid to tell you whatever nonsense they have to say to get you to sign up. So when you sign up, before you join, talk to other veterans like myself who tell you how it really is, so you're fully aware. And if you want to do it, more power to you. Thank you for serving. If you decide it's not for you, that's a totally acceptable response. But don't join and then do it in a manner that is like, I can't, they're just a little too rough. They're supposed to be rough. You're morphing into someone who's gonna have to go, who could be ordered to die. The military can lawfully order you to die in battle. They can order you to charge a hill knowing you're gonna get killed. That's lawful. It's terrible, it's awful, but it's legal. So there's a difference between what's legal and what's illegal, and what's correct and what's incorrect. Massive difference. Keep all that in mind before you sign up. I'm sorry for such a draconian example, but again, now I'm the old guy at the VA complaining about life. So that's what's happened in my scenario. Protect yourself, protect your family. don't talk to investigators, and thank me after your life gets back to normal. All right, well, have a great day, everybody. That concludes our webinar. I appreciate your participation and involvement, and if you have any further questions or you'd like a one-on-one consultation, you can reach out to us. My contact information is down here. So my office is in Sugar Land, Texas. It's right outside of Houston. With the pandemic, we moved my office closer to my house because it just makes more sense. And I'm also closer to the airport now. And I spend about 120 days a year on the road. So I'm either in my office or I'm at the airport, my vehicle parked there, and I'm traveling somewhere. Houston's a great logistics hub to get anywhere in the world at any time. There's tons of direct flights. I can get to Frankfurt in 10 hours. I can get to Alaska in about 10 hours, and I spend time between both. I have trials upcoming around the world, all over the place. So when I'm at home, my family's parked here in their neighborhood, enjoying their life while I'm advocating for clients around the globe. And I'm appearing probably in your time zone in the future, somewhere. I guarantee it. I already have 7 or 8 trips lined up for 2025 to advocate for clients around the world, to fight injustice on behalf of those who retain me. Hopefully you'll never need my services, but if you ever do, this is how you can get a hold of me. Thank you for your time today.